Because may I just broadly tell your lordships what my submissions are going to be, because lots has already been said, Malad. So we'll need to encapsulate, Malad, our submissions so that everybody gets a chance to argue. Malad, what is your lordships considering today? If you look at 200 and 201, the first question you have to ask yourself is, what's the nature of the power exercised by the governor in 200? Is it legislative? Is it executive? What's the nature of the power exercised by the president in 201 when the matter goes to him for consideration? Is that on the aid and advice of the Council of Ministers at the center, or is it his personal power? Those are the two fundamental questions that your lordships will have to ask yourself. I'll assume for a moment, Malad, that it's an absolute executive power. Let's assume against myself. So consider this, Malad, the conundrum, which is a constitutional conundrum that your lordships will have to face. A legislature in a state is reference to an item in list 2, say distribution of electricity, or an exclusive item in list 2 passes the legislation. That's the will of the people, and that's a sovereign act. So your lordships will have to come to the conclusion to decide against me that that sovereign act of the legislature need not be implemented by the executive. He can withhold it. So for the first time in the history of constitutional law in this country, your lordships would hold that the will of the people need not be implemented because the governor chooses to withhold the bill. It's a proposition, Malad, which is unaccepted under any principle of constitutional law. It cannot be. Why, Malad? Now let me give your lordships why. If you look at the theme of the Constitution throughout, in respect of the executive chapter, Malad, in relation to states, or the executive chapter in relation to union, you will find that the executive at no stage has any legislative power. If it comes to the executive in the union, Malad, the president will act on the aid and advice of the Council of Ministers. President has no individual function. When it comes to the state, Malad, the governor will act on the aid and advice of the Council of Ministers. The governor has no individual function. If at all, the governor has two functions, Malad, which are somewhat different under the Constitution itself, which is 356. But that's a recommendatory function. It's not a decisive function. The governor will recommend that the functioning of the state is such that that cannot function under the provisions of the Constitution. Who decides? The government of India. Who decides finally whether that's right or wrong? Your lordships. So you have to address that question first, Malad. Let's forget about case law. Fundamental constitutional law. 356 is one such power. 161 is grant of pardon, again, exercised on the aid and advice of the Council of Ministers. And 311.2 is another power. 311.2. Inquiry not necessary to dismiss a government servant because of the satisfaction of the governor. Again, on the aid and advice. Give me one provision in this Constitution, one, that allows the governor to exercise any power which thwarts the legislation. We'll come to timelines later, but at the moment, I'm not concerned with it. So you have in 200, in a part of 200, a power to allow the executive, namely the governor, who doesn't have to act on the aid and advice of the Council of Ministers. He doesn't consult the union government because he has no right to consult the union government, but he will just withhold the bill. Well, such a proposition is untenable from any standpoint. My learned friend also once conceded when we were interpreting 111, if your lordships will remember, that when Parliament makes a law and sends it to the President, Mullas, he has no power to withhold.
No, he can send it back. Once.
That's all. But that's the very power here, Mullas.
Once he can withhold.
Yes, but the word withholding consent is there. But there is no absolute power there to withhold. So how is it, Mullas, that withholding consent he has no power, but the governor has? It can't be, Mullas. See 111? That very expression is there. Yes. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or he withholds assent.
And thereafter the proviso?
Then it's provided that the President may as soon as possible. Same thing, Mullas. So therefore, here withholding consent is not absolute, no absolute power to withhold consent. But the interpretation is in 200 he has that absolute power. So the same expression used in two articles would be interpreted differently by this court. That's what my learned friend wants your lordships to do.
The difference in the executive power.
Yes, it's the same thing. And Mullas, kindly see, I'm not that, now that I'm in that, read 200 once again with me. It's very interesting. The second proviso to 200. It's very interesting. Second proviso to 200. I'm digressing a bit, Mullas. It just occurred to me. Sorry. Provided further that the governor shall not assent to, but shall reserve for the consideration of the President any bill which in the opinion of the governor would, if it became law, so derogate from the powers of the High Court. Shall not assent to.
Yes.
Different from withholding assent. It's my learned friend's argument, withholding assent is shall not assent to. No. Permanently. Second.
So according to you, where an absolute power was intended by the Constitution,
Yes.
not to give assent,
Yes.
this specific mention has been made by the Constitution.
That's right. That's
in the Constitution.
in the Constitution.
Therefore, that can't be read in the first proviso.
Absolutely.
Or in the main.
That's correct. The concept of withholding is itself a temporary concept. Well, let's withhold, send it back. Withhold, send it to the President. Right? That act of withholding is an act
For that, these two options.
for that only. I'll do it tomorrow, Mullas, now.